is Michael Kovrig. He works with an independent organization called International Crisis Group. It's an NGO that carries out field research on violent conflict. But he spent more than a decade in Canada's Foreign Service, eventually rising to the position of vice consul at the embassy in Beijing. It appears the last activity on his Twitter account was on Sunday. So far, China's foreign ministry has refused to comment. When it comes to the case of Meng Wanzhou, Canada finds itself caught in the middle between the United States and China. One of the ways Ottawa has tried to remain neutral is to focus on the rule of law in this country. For more on that, let's go to Sarah Galashan in Vancouver. Sarah, let's talk about the rule of law in Canada as regarding the arrest of Meng.
Right, so Carol, Meng Wanzhou was arrested. It was a provisional arrest, and it was made from the request of the United States as per our treaty relationship with the U.S. It's a reciprocal agreement with the U.S. In other words, if Canada made a similar request, they would be diplomatically obligated to fulfill that request for Canada. I say it's a provisional arrest, meaning that the U.S. now has 60 days to provide Canada with what's called a record of the case, important evidence for the Canadian courts to evaluate this request for extradition. And then Meng Wanzhou has the opportunity, of course, to appeal. Now, we know the basis for the allegation is that Meng, who's the CFO of Huawei, a Chinese telecom giant, that she broke U.S. sanctions by doing business with Iran and did so under a disguised company called Skycom. But the allegation is that Skycom and Huawei are essentially one and the same. Now, she and Huawei deny this. The Canadian judiciary would have to agree, and there are reasons why the Canadian judiciary might not. Let's put the board up and go through them. First of all, the offense has to, for extradition to be granted, the offense has to meet the principle of what's called double criminality, meaning it has to be a crime in both the United States and in Canada. Officially, the charge is fraud, so that would qualify, but the sanctions part of this could be a loophole because Canadian sanction laws are a bit different. Also, the alleged offenses were committed outside of the United States, not on U.S. soil. So it's possible, it would be rare, but it is possible that they could turn down an extradition request on that basis. And that's according to an extradition lawyer that CBC spoke to earlier today, who also points out that regardless of what a Canadian judge were to decide, it is not solely the decision of a Canadian judge to make when it comes to extradition. Take a listen.
Ultimately, the Minister of Justice will have to make the ultimate decision about whether the individual is going to be extradited or not. And that is a decision that involves not only the law explicitly or concisely, but Canada's diplomatic obligations as well.
But earlier today, Foreign Affairs Minister Chrystia Freeland assured that Canadian courts will be respected regardless of the kind of pressure that might be coming from China on Meng's behalf. Take a listen to her.
It comes to the case of Ms. Meng. I think it's really important to be clear that Canada is a rule of law country. Being a rule of law country, you can't, it's not like going to a buffet. You can't sort of say, I follow rule of law for these two dishes because I really like them, but this one I don't like so much, so we're not going to be rule of law in this matter.
And all of this likely gets underway as of February 6th. That's when they're going to be setting the next court date to get underway with an extradition process that, Carol, it is believed could take perhaps years to get through.
All right, Sarah, thank you very much.
You're welcome.